absolutely can get a DUI even though the substance you are taking or supposedly impaired by is lawfully prescribed to you. You can have the prescription in the car. You can show the police officer, here, this is my prescription. My doctor told me to take this. It's totally irrelevant for purposes of DUI that you have a prescription for that drug. Georgia does not permit you to use that as a defense, in other words, to say, well, this is my prescription, I'm authorized and in fact arguably ordered to take this by my physician. That doesn't provide a legal defense in Georgia. Any substance whatsoever, if it impairs you to the extent that you are a less safe driver, can be used as a basis to charge you with driving under the influence in Georgia. Now, the one interesting thing is that if you have a prescription for the drug that they're claiming made you impaired, the Georgia code, the DUI code, says that in order to be guilty of a DUI, you have to be rendered incapable of driving safely while taking that prescription. It's a slightly different wording than the general DUI less safe statute, which says that you're a less safe driver. That's all they have to prove. Whereas if you have a prescription you're lawfully issued, it says you have to be rendered incapable of driving safely. Now, the courts have said they're the same thing, okay? They've said that those two phrases mean the same thing, but I can tell you for a fact, if a jury is told the government has to prove beyond a reasonable doubt that you were rendered incapable of driving safely by virtue of taking this prescription, that's much more powerful language, and you want that when you're facing a jury and they're determining whether you're guilty or not.